casinos. My dad owned 6 hotel casinos there. It was all run through the Silver Slipper Hotel Casino, and he owned the Sands. He owned uh, Frontier. I can't name them all that without a list. I'd have to see the list. But he owned 6 hotel casinos. And when I want ability with those casinos, like if I want the air for the casino air on, I can activate the system through this system. And when I get out, I'm going to have a capability. I'm not sure where the system I would enter into, like one of the hospitals or something. They've got the capability for the state and all the departments of the state's official capabilities.
Do you think he owns those casinos or is he just mad? Well, I'll tell you that he has been locked up since 1977. 1977, and he has not been paroled since. He was given a 5 to 100-year sentence for aggravated kidnapping and SA. And we'll review the appeal and on that crime at the end of this hearing. Now, this hearing, it can determine whether or not he's going to die in prison. So there's a lot riding on this, and I'll share the details at the end.
You've been inside for a very long time.
I love it.
Do you think that? Do you think you can manage to succeed on the outside?
With the right amount of treatment and the right amount of help, yes, I can.
Okay, good.
But,
What about? You've had some problems in prison, and including a recent incident that concerns me. That was a
refusal to go back in my cell with the individuals I was living with.
pardon?
It was a refusal to go back in my cell with the individuals I was living with. At that point, I wanted to move
Yeah.
from that particular area because there was going to be a fight if I didn't. So I said, I'll just get out of this cell and go into another. It was an 8-man cell.
Yeah. Well, they characterized that as a fighting assault, but I agree with your assessment. It really never got to that.
I got out of there before it did.
Did they? Did they have a hearing on that?
They dismissed it.
Dismissed it.
Yeah.
So, and what are you up to now?
I'm in the solid program. It stands for, let's see, what does it stand for? It says successful offenders. Overall, it's about treatment progress.
Mhm.
I can't remember exactly what it stands for, but it's a solid program. I'm sure you've heard
Yeah.
of it.
I hear good things about the solid program.
It is a pretty good program. I've been in programming since I've been in prison. A number of programs. I've been in the revamp program, which was a sex offender program. I started in the revamp program. I did about a year and a half in there, and then I got out of that one when I was put into the Advantage program, the Phoenix program. These were all mental health programs. So from that point on, I was in group therapies with Dr. Carlisle. I was in therapies with Dr. Austin. Those are the old psychologists and psychiatrists. Dr. Rowe, there's the old
Sure.
psychological doctor for the prison. Yeah, I'm sure. I've been programming, but I have not been in the living program with the sex offender treatment programming, except for the revamp. The rest of it's all been mental health, and I've tried a couple of times to get into the sex offender programming, but it didn't wash out. They don't want me in the sex offender programming. They say I'm a mental health inmate, and I need to be in the mental health programming,
Mhm.
and that's why I've been in all the mental health programs that they've come up with.
And
Prison.
are you currently taking any medications?
About 10 medications in the morning and 3 medications at night. I've got kidney, psychiatric, and heart medications.
Mhm. How many at night?
3,
Uh-huh.
3 or 4. I think I take 1, 2. No, I take 3. Tylenol.
That's a lot of medication. You think they're helping you?
The medications are necessary. I don't know as far as
Mm.
the changing would be because I've been taking the medication since I came into prison. Dr. Kiger told me the day I walked through the door at Draper, he said, "You're going to take this medication one way or the other. You're going to take it in the mouth. You're going to, go from there.
Mhm.
And he said, you will take the medication. That's all there is to it. Back then, they didn't have hearings for, forced medication and stuff like that. They just forced you. If they wanted you to take it, you was going to take it, or they'd hold you down and give you a shot.
Mhm.
And I've got held down a few times to be given a shot because I refused medications. I'm addicted to the medications now. Without those medications, I get sick. I get
Mhm.
very violently sick. It could possibly kill me if I stop taking the medication. So I don't neglect my responsibilities to take those medications.
Mhm. How about mental health counseling? What are you getting?
Well, the counseling itself there's classroom called core class. There's seminars that we teach and they teach. The other people in the programming all have seminars to do, one a month. And a seminar lasts for about an hour, and it's descriptive on whatever you choose to enlighten the group with. Uh, so that's one form, in the pamphlets that we use in the core classes are structured by the what do they call those? Like the Federal Bureau of Investigations, Federal Bureau of Inmate something. But those are pamphlets that have already been assessed in other groups, in other program settings, and we're just following in the suit of what they've already
Mhm.
started programming with those pamphlets and books that we read from and discuss things. It's like a big group therapy, but it's structured by the books.
Mhm.
Other than that, the group therapies are kind of open to, say whatever we want to say or listen and see what people have to say to you. But when we go into those core classes, we start with treatment programming or behavioral programming or whatever the topic is of the day. And then we discuss that and go around the group and everybody gives their input on what they feel is going on. If it breaks off into a group discussion, then that's making progress as far as I'm concerned.
Mhm. And you've seen the report, the most recent one. It recommends that you complete the core program prior to being released. Do you have any idea when you'll be able to complete it?
I've completed two already.
Mhm. You've got some history of treatment. Obviously, the specialists in the area think you need more.
That's what they've been saying for
And
a long time.
and I know that where you're housed now, there's limited opportunities.
There's no better programming in the prison.
The report, as you've seen, recommends that you be moved to current to get some additional mental health counseling. Do you
That's where I
have it?
came from.
Pardon?
That's where I
So
came
you're
from.
in current right now?
No, I came from Current
Uh-huh.
to the Bear facility. I went to Bear 4 from Current. And I started this out in this prison when it opened in Current. I was
Mhm.
there until whatever the date was. It's been about a year and a half that
Yeah.
I've been over in Bear 4. So I've been in the programming on Bear 2. I've been in the programming since that one opened up. So going back to Current would just be like going back to square one.
Yeah. Of course, I have no control over that.
No, that would be the housing and people.
Yeah.
That's why I got in
Oh, well,
trouble.
I was interested to see the recommendation that you go to current because I frankly didn't understand
Why they
what
want me
that
back
would
in Current.
accomplish.
Yeah,
But
that wouldn't accomplish much.
yeah.
So starting over again because Current mental health over there, I've seen some of the people when I've gone over to the psych hall a couple times from there too. I've seen some of the people that I used to know over there, and they're doing the same things that they were doing before, and like putting things around their neck, choking themselves, or cutting on themselves, and it's the same people doing the same things. I'm not doing those things.
Uh-huh.
I'm doing different than I was. I'm changing, and it seems like the people in Current are there because they can't change or won't change.
Hmm.
So why would they want me to go back there? I have no idea.
Well, they recommend that report recommends some additional mental health treatment and sex offender specific treatment. How do you feel about that?
Like I said, I've tried sex offender programming, and the revamp program was a long time ago.
Yeah.
It's been about 48 years. And I was in there, and then I was in group therapies. I didn't have a structured program to be in, but I was in sex offender group therapies, and I did that for years.
Yeah.
I have more of a mental health program. I have more of a mental health condition than a sex offender condition right now.
Mhm.
And it's been that way. And that's why they keep putting me in the mental health systems.
Yeah. Well, yeah, you wrote in your request for a rehearing um, uh, a pretty comprehensive plan when you released. Okay, tell me how you think that's going to go.
For support, well, to tell you the truth, I inherited some stuff from my dad, but I don't know if I'll ever get any of it. The programming works for me.
Mhm.
So if I wanted to activate something like CIV 00.02326 echo status holding, that would be a capability that I would be able to introduce with my own abilities.
So you have any ongoing contact with family members?
No, not at the time. My mom's dead, my dad's dead, my brothers are dead. I found out before my mom died that Jack, who's listed as my dad, is not my dad. Howard's my dad. And that's where I got the inheritance from. It's from my dad, Howard. I was there on the weekends with him, and I lived in with my brother Jack, who at that time I thought he was my dad. I lived with them during the week. My dad was named Howard Hutchison. He also was known as Howard Brevard Hughes Jr. And he left me He left me Summa Corporation, and I got that through the tablet and the legal part of the tablet. They'll converse with you if you type it fast enough. They'll you can stay up with the program. But anyway, I won my case in a civil suit through a jury trial through the tablet, and they give me the inheritance of my dad's estate, Summa Corporation.
Mhm.
That's how I'm able to activate a lot of the stuff that I do. Like I'm sure you're gonna ask me about the air. Uh, those things are something that my dad's ability gave to me. He gave me the codes and the capability there. I just programmed a tablet for the officers and the staff here. It will turn the air on. So if I'm released from prison, I won't have to be the one to turn the air on. It's in the programming of the tablet, and that's all that tablet's good for anymore.
Mhm.
They push the buttons in the right order as I show them to do that, and it'll come on and it'll stay on until it's turned off 24/7 because it's not on the identification process of the programming anymore. That's where you got to hold it up in front of you and it takes a picture of you and gives you recognition and lets you into the programming. I got out of that programming and re-established the programming in the tablet so that it's just straight up. It's a Chinese system is what I got into, and I utilize the Chinese capability in the United States of America's programming system to articulate the ability to get what medications and treatment that the program will allow. It's pretty good stuff. It
Mhm.
works pretty good.
So where would you live if you were released?
I'd like to go to Salt Lake for a while and get on Social Security and get on Medicaid, Medicare. I'm almost 67. I'll be 67 in January. And I think 66 is the senior citizen age that you can start on those. Once I'm there, I was thinking about either going to Las Vegas and living in one of my hotel casinos. My dad owned 6 hotel casinos there. It was all run through the Silver Slipper Hotel Casino, and he owned the Sands. He owned uh, Frontier, I can't name them all there without a list. I'd have to see the list. But he owns 6 hotel casinos. And when I want ability with those casinos, like if I want the air for the casino air on, I can activate the system through this system. And when I get out, I'm going to have the capability. I'm not sure where the system I would enter into, like one of the hospitals or something. They've got the capability for the state and all the departments of the state's official capabilities. So hospital might be a place I would hang out to just to get my air, because without it, I'd get just as sick with if I stop taking the medications,
Mhm.
because there is a definite medicated capability within that process there. I'd get sick. I'd get sick.
As you're 67, theoretically, at least you're at retirement age, and I take it you're not, other than having some expertise, you don't have any plans to get employment?
No, I'm not. I would like to be able to live in one of my hotel casinos and run the show from there. That would be just my stuff. Simple
Yeah.
Corporation. Simple Corporation owns quite a bit of stuff. It started with Safeway's food stores, and from Safeway's he built on and added and got bigger and bigger and bigger until he had an estate.
Mhm.
And that estate now is not in process anymore, because, like I said, through the tablet, it was a jury trial. One of the judges in Utah is what's his name? Beecham, uh, Judge Beecham, and he handled a lot of the cases. I told him where the money was in Walker Bank. I gave him the account because my dad gave me the account number. He got the money out of the Walker Bank account and got the documents and the deeds to all his properties out of a safety deposit box. I talked to him about that on the tablet. So I didn't go to a trial like this where we're in person, face to face, but I could type to them and they'd type back. And what's Beecham's first name? Let's see. I think it's George H. Beecham.
Mhm.
Yeah.
So, you've answered all my questions. Is there anything that we haven't discussed so far that you think the board ought to consider?
Well, you haven't asked me if I plan on reoffending or anything like that. And my answer to that would be a definite. I have.
Yeah. Well, I've seen, I've read your written report, and you've shown some insight into your past problems and indicated that you think you've managed to
I've
get
got to
past
the point
those.
where I think I would rather not hurt people than hurt people.
Mhm.
And
So, and what do you think it'll take to achieve that? I mean, I'd like to think that you wouldn't have any temptations, but you have a serious history, and I'm wondering whether you have any specific ways that you intend to avoid further problems.
being around people,
Hmm.
that's one of my biggest problems is antisocial behavior. Not so much as a mental health program process, but antisocial is you don't want to be around people and you don't want to associate with people a lot. And I think that's also in the report that
Hmm.
they think that I need to be around people.
Yeah.
And that I think is one of the biggest indicators of what my actions will be as far as making decisions about what I'm going to structure my life with. If I've got people around me, it'll be a lot easier to structure what I do than if I don't have people around me.
Yeah.
Because if I'm all by myself and I'm sitting there, I'm going to smoke cigarettes, I'm going to drink coffee, I'm going to watch TV and listen to radio, I'm going to pace around the house, whatever the case will be. But if I'm around people, I'll be actively interacting with someone, and that keeps your mind busy and keeps your
Okay.
focus a little more.
I think that sounds like a good plan.
Well,
Anything else we ought to consider?
I'm done with it.
All right. All right. If that's all, we'll conclude the hearing. Thank you. You'll be hearing from us.
Thank you very much.
Okay, I'm a little bit embarrassed to admit that I did Google the name and different variations, like hotel magnet and melana. There's not even anything close. So no, he doesn't own hotels, and also Utah denied. And thank you, Sir Richard, for providing the results. And they actually wrote a paragraph onto why they denied it. Sometimes it's copy paste, sometimes it looks like new writing, and this looks like new writing. And they said that after reviewing all the information submitted and the information from Mr. Mellon during the rehearing, the board does not find sufficient cause to grant the determination request. The board considered Mr. Mellon's institutional behavior, relevant risk assessment, and overall treatment and programming. The board finds Mr. Mellon currently poses too much risk to public safety to consider his release. Accordingly, the board denies redetermination request, no change to the expire life decision. So oftentimes we see where they create a new parole hearing date, but no. He, maybe he gets out when he's really sick to hospital, but I think he's probably going to die in prison. And he might be regretting his move. He let his survivor go out of the car. So we'll read over that appeal and what he went through. But he kidnapped her and then let her go and said, "Don't rat on me," and she did. And she took the stand in a jury trial. And what this appeal is about is whether he was legally competent. And his defense attorney declared him schizophrenic. And the prosecution, I think they ended up saying no, he's capable of standing trial, and they attacked his witnesses, and the jury found him guilty. Now, I mean, I think it's pretty safe to say that he's not mentally there, but it doesn't mean that he should ever be out in the public. Now, I guess the other question is, does he belong in a psych ward? And I don't know much about this. I know that like the U.S. closed all their psych wards, and I'm not sure that he'd want to be in a psych ward anyways. And I guess they have a psych division. That's why, in Utah. But I'm getting out of my. But I think that this is a worthwhile hearing for anyone who's debating this, maybe getting your PhD in how to handle these type of patients in the Department of Corrections. I hope that this is that if you find this when you're writing your thesis, that it's of value to you. But yeah, let's just go into the appeal, because who needs to hear Mandy talk about things he knows nothing about? But that pretty much is every parole hearing we see anyway. So what's different today? All right. So July 17th, 1978. Again, to think, can you imagine think about that. That's your life in a prison. And he touched on how some things had changed. Back in the day, they'd strap you down, and you couldn't go to court for it. I'm sure they strap you down now as well, but now you can actually fight it in court. So the defendant, George Mellon, appeals his conviction by jury of aggravated kidnapping and aggravated SA. He contends that the trial court committed prejudicial error in becoming adversarial in questioning a defense witness and in excluding the testimony of two lay defense witnesses offered in support of his defense of insanity. And I can understand why you would dismiss a lay witness. They're not medical, they're not experts, so how can they give any testimony about your insanity? And I'm guessing it might have been his mother or something like that, right? Now, the victim, TS, a young woman, 20 years of age, testified, and good for her, that is a survivor. She testified against him. And who knows how many. And when you say survivor, I don't say this lightly. It's not just a survivor. It is heroic in a way. And I don't like to overuse that word. But the bottom line is there are a lot of people that can't go through this. And by her going through it, I think it's safe to assume that she saved others from falling into, right? He would have kept on offending, my opinion. And the idea that he's caught in his first chance, I just don't believe that. The odds are you're just not caught your first time. So a young woman, 20 years of age, testified that on the afternoon of March 13th, 1977, she was walking northward on State Street in downtown Salt Lake City when the defendant pulled his car alongside the curb and asked if she wanted a ride. She refused, but he grabbed her arm and forced her to get into the car and asked for her address. He drove there, stopped momentarily, then quickly drove away. Inasmuch as the appellant's brief does not disagree. Okay, Inasmuch as the appellant's proof does not disagree with the state's version as the facts, we spare unnecessary detail. The victim says that the defendant put his hands on her throat, threatened her life, and thus, by fear, compelled her to perform. And it's interesting they use this word. I don't know if this is a 1977 word or a Utah word, but this is the updated version of what he forced her to do upon him. Whereafter he drove back near her home, again threatened her, warned her not to contact the police, and let her go. And Sir Richard has in the notes, I bet you he wished he didn't let her go. As a result of the inquiry and investigation, the defendant was arrested on May 4th, 1977. So how long did it take for him to get arrested? July 17th. No, that's not. May 4th, 1997. This is March 13th. Wow, it took April 3rd. It took more than a month to get him. Isn't that interesting? He's arrested on May 4th, 1977. He was temporarily committed to the Utah State Hospital for examination and observation. Pursuant thereto, he was released and certified as competent to stand trial. In subsequent conversation with the police, he admitted his complicity in the above described episode. You know, and to think all he would have had to do is ask for an attorney, and they probably wouldn't have gotten him. But who knows? It was a jury trial. So the defendant's first contention relates to the testimony of the psychiatrist Dr. James Whitten, who examined him in August 1977, thus 5 months after his crime. He diagnosed the defendant as being affected by paranoid schizophrenia and stated that it was his opinion that the defendant was legally insane at the time of the offense. After cross-examination, the judge questioned Dr. Whitten as follows. The court: I take it, doctor, that you make your diagnosis of the mental state of an individual based on his behavior pattern as certain time as to what he says and what he does in your experience. Is that correct? Again, this is the judge asking, not cross, not the prosecution. A, that's correct. Mostly his thinking at the time. And this was a jury trial. Do judges do that? Would a judge ask? The court. So if you were to look back to March 13th, what he says and does at the time would be in his behavioral pattern. And that's what you would have to base your opinion on. Answer: I would. That's true. The court. And schizophrenic goes in cycles, does it not? Answer: characteristically. The court. And they are responsible at times. Is this correct? Answer: quite. The court. And at times they do know the difference between right and wrong and can choose the right from the wrong. Answer: absolutely so. The court. So it depends upon the behavior pattern at any particular time that you're trying to examine as to whether or not he would be responsible. Answer: that's correct. The court's cross-examination of the witness. I don't understand. You said that's the judge, though. The judge questioned Dr. Whitten as follows. What am I missing? But basically it's saying, well, so it's, I don't know. It's like a pattern. Okay, so the following observations are to be made in regard to the defendant's attack upon the foregoing procedure. In addition, the important right to have access to the court. It's equally important that the court be fair and impartial and committed to the purpose of seeking truth and doing justice without bias or prejudice, fear or favor. In pursuing that objective, it's not to be questioned that particularly in a jury trial, a judge should maintain an attitude of neutrality and should not. So this isn't completely normal, right? This is part of his appeal. A judge should maintain an attitude of neutrality and should not, either by his comment or demeanor, indicate his opinions, either as to the credibility of evidence or on the disputed issues of fact. Consistent with the foregoing, the judge should and normally does exercise restraint in examining witnesses so that he does not unduly intrude into the trial or encroach upon the functions of counsel. So I think I was right to ask this question. For those law nerds out there, please let me know in the comments section, because again, you would think that that's the job of the prosecution, not the judge. Notwithstanding what has just been said, the judges does have a function beyond sitting as a comparatively silent monitor in the proceedings in order to discharge its responsibility of carrying out the above stated objectives. It is within a, and when you write the comment, if you can at me, YouTube notifies me that way. Otherwise, I'll probably not see it, unfortunately. It is within the prerogative to ask whether the questions in the witnesses is, in his judgment, and necessary to desirable, clarify, explain, or add evidence as relates, blah, blah, blah. The judge, Dr. Wen, blah, blah, blah. Exclusion of evidence from insanity. After Dr. Witten testified, the defense indicated its intention to call a lay witness. In support of its defense of insanity. The court excused the jury in order to hear the proffer of the testimony. The proposed witnesses were attorney Ronald Yankich, who had earlier acted as appointed counsel for the defendant. Okay, not his mom. It's the attorney, so he must have seen, wow, this guy's nuts. And Mr. Randall Oyster, a psychologist who had worked with the mental health center with prisoners at the county jail. Both had conversations with the defendant. In summary, the offer was that the defendant had related to them certain fantasies and delusions upon which they would agree with the diagnosis of Dr. Witten, that as of the time of the conversation considered a considerable time consequence to the crime, the defendant was paranoid schizophrenic and not responsible for his actions. On the basis of that proffer, the court excluded the proposed evidence. You would think that they would allow the jail psychiatrist, right? I mean, he's an expert, so I don't know. I think that both of these appeals are pretty decent appeals, just from what we've seen, right? They both seem, and this is the type of stuff that makes it into the setting precedents and whatnot, right? I don't know. In regards to the defendant's attack on the ruling, we have no disagreement with the cases cited by him in indicating that under appropriate circumstances, a layperson may testify in his judgment someone else is insane. The appropriate circumstances are where the symptoms of insanity are so obvious that a layperson could reliably form a judgment thereon. That is but one aspect of mental disorder. It is to be realized that the term insanity is a broad one, used to denote a wide spectrum of mental defects and diseases. They vary between the extreme just referred to, wherein the manifestations are so plain that anyone could see the subject is insane, to cases on the borderline or special aberrations which are difficult to perceive and diagnose. Normally, I don't read into all of this, but I kind of got sucked in to the rabbit hole here because it is quite interesting. And it's also like going through a time capsule. Remember, this appeal was only answered back in 1978. I wonder how it would change today with differences in medical understanding, right? I have no idea. I'm not, but I think someone one day might find this to be interesting. From what has been said above, including the tests in hospitals, that the certification therefrom, it does not appear that the defendant manifested any such obvious symptoms of insanity that a layperson could reliably form such a judgment. Really? I mean, if he's talking about owning casinos, I think all of us can say, yeah, he's crazy. Now, would we know if he's putting on an act or not is a different story, but I don't think even the trained would for sure know. You always can get 5 experts in a room and 5 different opinions. Moreover, as the trial court observed from the prof evidence, it did not appear that either witness would have the basis for judging the defendant's sanity at the same time of the offense. In addition, the fact that they were cited, which would make the proffered testimony extremely questionable as to the probative value, the court was aware that the position of the defense had already been covered by what must be regarded as the superior testimony of Dr. Witten, so that the testimony of the lay witnesses, in addition, being highly questionable probative value, would in any event be cumulative. I disagree. I think a jail psychiatrist is a meaningful witness. And I would also say that his attorney is a meaningful witness because I think it's less likely that he pretends to be crazy in front of his attorney when everything is you know, because of his special character, evidence relating disorder of the mind. The general rule is that the trial court considerable latitude discretion in ruling of such evidence, and that they should not be disturbed unless it clearly appears that he abused his discretion and thus committed an error in which prejudicial to the evident, and that there is a reasonable likelihood in the result would not be different in error, blah, blah, blah. Okay, we're at the end. So let's just get to the end. For those of you who are still watching this, I salute you. Let me know in the comment section that you're still here so I can say thank you. In support, and at me when you do it, in support of the conclusion just stated concerning the defense of insanity, it is also to be kept in mind that the jury had both the duty and the privilege of considering therewith all of the evidence in the case concerning the defendant conduct in relation to his apparent planning and carrying out the crime. It hardly needs to be 50 stated that there is ample basis therein upon which they could believe beyond a reasonable doubt that his claim that he was insane to the point of non-responsibility at the time, but attempted to delude them, and that he knew very well both the nature and the evil of this violation upon this young woman. I really, when I'm reading out loud, sometimes I have no idea what I'm saying. So what did they just say? There's ample basis which they could believe beyond a reasonable doubt that his claim that he was insane to the point of non-responsibility at the time was but an attempt to delude them. Okay, so they're saying blah, 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 but then they conclude that he knew very well both the nature and the evil of his violation upon this young woman. There is shown no error in prejudicial defendant that would warrant overturning his conviction. So I think my understanding is that they're saying the bottom line is that he knew what he was doing when he did it, and he's guilty. And I agree, he needed to be locked up. That is an interesting. I guess you can always sum it up as like, well, you might be, you knew what you were doing was wrong, though, right? Unless someone wants to actually believe that he did, but either way, you need to be locked up. I guess the question is it, and I just don't understand this. Is it an insane asylum or is it a prison? There are people today that believe, well, if you're properly medicated, then you should get back out because properly medicated, you'll be safe to the public. And I don't like that answer because I always say, oh, and then if they stop taking their medication, you want to take that risk? No. So I don't like that either. And I always say you got to protect the potential victim over someone who's already proven they can derail a life. And, you know, about this long unpacking, a 20-minute unpacking for a 20-minute parole hearing. And I want to let you know, this does not help the algorithm. The algorithm hurts you in the channel when you upload something and only, you know, people who cut off 50% of it's seen. It hurts the algorithm. I don't do this to help the algorithm. If I was caring only about hits and views and getting more whatever, I would do a 3-minute unpacking because that I know that more of you I know that most of you don't continue watching to the end, but I'm not doing this just for that. I'm doing this for those who actually want to understand how the system works. So I'm sharing that it's not the length of the video that makes it more successful. It's actually usually it's the most concise. It's the ones that I unpack the least because it has a longer, more people stay on to watch it, and that has a huge effect in the algorithm. I'm just letting y'all know for any of you who are still watching. Thank you, Sir Richard, for providing the info and the dates when the decision comes in. And with that, I'll let you go.
Frontier, I can't name all of that without a list. I'd have to see the list. But he owns 6 hotel casinos. And when I want ability with those casinos, like if I want the air for the casino air on, I can activate the system through this system. And when I get out, I'm going to have a capability. I'm not sure where the system I would enter into, like one of the hospitals or something. They've got the capability for the state and all the departments of the state's official capabilities. So hospital might be a place I would hang out to just to get my air, because without it, I'd get just as sick if I stopped